We are on the record in Manistee, Michigan for the video deposition of Craig A. Rolfe in the matter of Debbra Eckhout versus the Township of Arcadia, Patricia Wilson, Greg Wisner, Janice Craner, and Mike Cederholm. This is a matter currently pending in the Circuit Court for the County of Manistee, case number 18-16454-CZ. Today's date is Thursday, June 7, 2018, and the time is approximately 12:46 p.m. I'm Susan Stiles, video operator and court reporter for Network Reporting. Counsel, if you would put your appearances on the record, I will then swear in the witness.
Frederick Stignilson from Jesse L. Williams Law and Advocacy Center on behalf of the plaintiff, Ms. Eckhout.
Brad Werda appearing on behalf of the defendants.
Mr. Rolfe, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the whole truth?
I do.
Sir, could you please state your full name for the record?
Yes. Craig, C-R-A-I-G, Allen, A-L-A-N, Rolfe, R-O-L-F, as in Frank, E.
And I think you mentioned this before, but you have not been deposed before, is that correct?
I'm pretty confident in saying that over my entire career, that's correct.
Okay. Have you conducted depositions?
Yes.
Okay.
Yes.
So you're fairly familiar with the conduct of a deposition?
I am.
And just for record, you are an attorney?
I am.
Just for my own benefit, I'm just going to go through a few things. I'm sure you already know them, but just for clarification.
Please do.
We're obviously being recorded.
Yes.
So we want to be careful not to talk over one another. So when I ask a question, please let me finish the question, and I will do my best to let you finish your answer without interrupting.
Very good.
And as you know, and uh-huh, and head nods and head shakes are not sufficient. So yes or no.
Yes.
And your answers today are under oath, and I'm sure as an attorney you understand all the potential liabilities of not giving truthful testimony.
Of course.
And if you don't understand a question, I have a tendency of asking some convoluted questions. Please stop me and I'll try to clarify, and we'll go from there.
Sure.
And if you need a break, let me know and we'll take a break.
Very good.
All right. So let's just get a little bit of background. You are the township attorney for the Township of Manistee?
Township.
I'm sorry, Township of Arcadia, yes.
In Manistee County, yes, sir.
And how long have you been the township attorney there?
I think since about mid-2000s. My best recollection.
Okay.
When Tom Wass, W-A-S-S, became the supervisor of Arcadia Township, which I will say, by the way, instead of Township of Arcadia, because it's a little less wordy for this purpose. He had been a township manager or superintendent in a township in the Plainwell area in southwest Michigan. And I had run into Tom Wass through probably doing educational conferences for the Michigan Townships Association, because my firm at that time was legal counsel for MTA. And I got a call from Tom one day, and he said, "Hey, we need a competent municipal attorney up here, township attorney, specialist. Are you willing to take us on?" And I was happy to do that for Tom.
As a township attorney, who would you say is your client?
The township, as a municipal entity.
So, for sort of a lay understanding, would that be that you essentially represent the township board?
No.
Okay.
That's not how I have ever seen my duty, my professional duty. The township board is the governing body of a township, but the township board is not my client. The municipal entity is my client.
So it'd be fair to say that there's not a single individual, whether on the township board or an employee of the township, that would be, that you could specifically say is your client. It is the township as a whole, the municipality.
That would be a correct view of my understanding of where my professional duty lies to the municipal entity.
If a township official or employee had interests that were adverse to the township, the municipality, then again, your duty would be to the township as a whole.
Well, my duty would always be to the client, but it's very difficult to answer a question like that in the abstract just based on your usage of your term adverse. But your understanding that I would think that my duty lies to the client is correct.
All right, and we'll get into some more of that in a moment. I'm going to start by talking about, are you familiar with the Freedom of Information Act requests and denials that are at issue in this lawsuit?
I am.
And I've seen in some of your billing that early on you did file an appearance and you've conferred somewhat with Mr. Weird, and I'm not interested in what you conferred about, but you have conferred with him.
That it would be a correct understanding.
And then at some point you, well, in this action you initially filed an appearance in the interest of the township and the individual board members, and then you later withdrew that appearance once Mr. Weird's firm came in. Is that correct?
I filed an appearance, and initially, let me back up. When this litigation was brought to my attention, I initially filed my appearance on behalf of the defendants to protect the interest of those defendants, the legal interest of those defendants relative to the pending matter, while the township obtained from its insurer a determination as to whether or not the insurer had a duty to provide legal defense to the municipal entity and or the individual named officials of the municipal entity. Because as you know, there's a pretty tight timeline for a first responsive pleading. And it's my experience over the years of my practice that insurer determination is typically not made within that time parameter. In the case of personal service, 21 days. So you don't want your client defaulted while an insurer determines whether they have a duty to defend or not.
Fair enough.
That was the purpose of filing my initial my initial appearance in this case.
And I'll just move to strike all reference, obviously, to insurance. You didn't ask about it. He brought it up, I think, but just for purposes of the record.
No problem. So, and I guess the reason I was asking that is because, and it goes back to my previous answer or question, that you are familiar with the FOIA issues or the FOIA requests and denials that are at issue in this case. So I want to draw your attention to one FOIA request that's not at issue in this case, but which I do believe is relevant. I'm handing you what's been marked. It was used in the previous deposition, so it's marked Deposition Exhibit 1, P. Wilson. Do you recognize that document?
I'm pretty comfortable saying I would have seen it at one time, probably contemporaneous with the date it was supposedly sent, September 22 last year, because it was sent to me, according to this caption, from Debbie, from the treasurer.
And do you recall that you notified the treasurer that you were not the FOIA coordinator, and then you forwarded it on to the clerk at that time, who was the FOIA coordinator?
I can't say today that I specifically remember doing that as to this specific request, but that would be consistent with the approach that I would ordinarily take with if anyone were to send me a FOIA request, since I'm not the FOIA coordinator for any client.
Okay.
That sounds like a likely response on my part.
I'm handing you what was marked as Deposition Exhibit 2 in Patricia Wilson's deposition, and it is a string of heavily redacted emails, but
I'm curious what your question is going to be.
my question would be that you mentioned that somewhat contemporaneously to that request, you probably had some communications with the clerk regarding that Freedom of Information Act request. I believe that the subject line in that email is FOIA. Does that seem like would be the type of email, without looking at the content of the emails, would that be the typical type of exchange that you would have with the clerk, some emails back and forth discussing how to address the FOIA?
Well, I can't tell from this Dep Exhibit 2 what the content was, and I don't specifically remember what the content was. But if you're asking me, would that have been what I have ordinarily, would it have been my practice to communicate with the clerk about a FOIA request directed to me? That would be a correct assumption for me to
Okay.
make as a general practice, assuming the clerk is the FOIA coordinator of the particular public body, as was the case here.
Okay. Now let's. So, in your practice, let me ask you this: have you spent time with Patricia Wilson, the current FOIA coordinator, at the time of the FOIA request at issue in this lawsuit? Have you spent time educating her or helping her understand the Freedom of Information Act?
I'm not sure sitting here today whether I have had that kind of a conference with Patty Wilson, the clerk, face to face, but I'm pretty sure in saying that there would have been some kind of communication with her regarding a FOIA request if she sought my assistance.
And but with beyond a specific FOIA request and questions about those, you have not engaged in any sort of training with her or trying to teach her how to respond, how to deal with the act?
Boy, that covers a lot of ground. I don't specifically remember doing that in a generic educational context. I tend to think, sitting here today, trying to recall, that anything of that nature would have been communicated more likely in the context of specific request. And the reason I'm pretty comfortable thinking that today, well, one reason is I don't remember putting on an educational conference per se for Patty on FOIA. And the other reason I think I would ordinarily have not been doing that is my experience with Arcadia Township has suggested to me from over an extended period of time, and including the current period of time, that this is a township that will oftentimes seek educational guidance, if you will, from the statewide Township Association, which is an educational body, the Michigan Township Association. And I know that I have, on occasion, in one context or another, referred the township, whoever the official may have been, to MTA as a source of some understanding and educational guidance that is free or covered by their membership.
Do you specifically recall referring Patty Wilson to MTA with regards to Freedom of Information Act concerns, questions, education?
No, I can't specifically say today that I recall saying, hey, go to the MTA website and check that out.
Isn't there there's like a hotline you can email MTA official or something?
I don't know.
Okay.
I don't know. But if the MTA website's for the members, it's pretty simple to use. There's buttons you can go to by subject matter, and I think most township officials that are MTA members, as I think Arcadia is, are familiar with that.
Okay.
Resource. It's a free resource.
I'm handing you what's been marked as Deposition Exhibit 3 in the previous deposition. Do you recognize that document?
I think this was one of Debbie's FOIA requests that's at issue in this case,
Okay.
if I remember correctly.
And okay, so And so that's dated November 10th, 2017, is that correct?
Yep, at the bottom by her signature.
And so this document, do you recall being notified about this document, this request?
I think so.
Do you recall how you were notified?
Assuming it was not brought to my attention directly by Debbie, and I can't sit here and tell you if that happened or not. I most likely would have been informed about this request from a township official, more likely than not the clerk, but I don't have specific
Would that have
recollection.
been via email or?
Most likely.
Do you think, without identifying obviously what the content of those emails, that if you were notified by email, then there would be email communications regarding this request between you and the clerk, Patty Wilson?
Boy, that's hard to say specifically. I'm going to say probably, but there could have been a phone conversation too. I can't sit here and under oath and tell you how that communication, what mode of communication there was, but I would say whether it was a phone call and or email, that's reasonably likely to have happened.
So you do recall in some form assisting and responding to this request?
I don't want to conflate this with the other request.
No,
but-
I'll leave alone the September
Right.
stuff. This specific request,
I-
November 10th.
I think so.
Okay. So, do you recall what determination was made with regards to this request?
Not any determination I would make. You're referring to determination made by the FOIA coordinator, the clerk?
Well, that brings up an interesting point. Who is responsible for making the determination with regards to how to respond to a FOIA request served on the Arcadia Township?
That would be, any initial determination would be handled by the person who's assigned that responsibility, which my understanding is, in Arcadia, is the township clerk, serving as the FOIA coordinator.
Are you aware that the township clerk, the FOIA coordinator, would you be surprised if I told you that her testimony was that she deferred wholesale to any of your advice that you gave with regards to the request?
Just object on form grounds, but you can answer.
Would I be surprised? I don't know how to answer that. Would I be surprised? I will say this. If my guidance was sought by the clerk / FOIA coordinator in responding to this FOIA request, I would have provided that legal guidance, but it would have been just that, guidance. It's not my decision to make how to determine how to formally respond to the FOIA request.
What documents, if any, did you and the FOIA coordinator working in conjunction identify that would potentially be responsible or responsive to that November 10th, 2017 FOIA request?
Whew, boy. I don't think I can answer that question today. And I really don't want to speculate.
So your testimony is just that you just don't remember, or?
I don't remember the specific guidance I gave to the FOIA coordinator about this request, specific words and so on. I don't remember that. It's been a while.
Okay, I'm gonna back up and we'll come back to this request. You agree that a FOIA coordinator in responding to a FOIA request would have certain duties under the Freedom of Information Act, right?
Sure.
And in fact, you have quite a bit of experience with the Freedom of Information Act, right?
A fair amount.
You've taken at least one case to the Court of Appeals.
Did I?
You didn't take a case to the Board of Appeals with regards to getting paid attorney's fees where the Freedom of Information Act requests have been made in your name and not in the name of your client?
His answer was, did I? I think he's saying you might have more knowledge about that
Yeah,
than he
I-
has memory of it.
Don't remember doing that.
Okay. So you don't remember ever taking a case to the Court of Appeals with regards to the Freedom of Information Act?
I don't think I've ever been the plaintiff in a FOIA case.
Okay. Have you maintained, is part of assisting townships with FOIA requests, is that part of your service that you provide to the townships?
Sure, I serve as general counsel for the township.
Have you maintained FOIA actions against others on behalf of clients?
Can you
Have you-
elaborate on that?
Yeah,
What?
let me ask you, I'll go back and do one more step. Have you filed for Freedom of Information Act requests on behalf of clients, whether townships or private clients?
Wow. So have I been a FOIA requester on behalf of a client?
That's the question.
Wow, over 30-some years, almost 40, as an attorney. I'm going to say probably.
And let me clarify, I don't mean that you yourself put your name on the FOIA, but have you filed Freedom of Information Act requests on behalf of clients as part of your job?
Other than the ones with Arcadia.
Just, yeah, in general.
Well, ever? Shoot. I'm going to say probably.
Okay.
And I assume you're aware, I filed FOIA request with the Department of State Police on behalf of Arcadia Township.
Yep.
Relevant to some issues that are involving this township.
Now, have you ever? I actually think that you may have hinted at a potential lawsuit when one of your emails with the Michigan State Police. But have you ever brought a FOIA appeal or maintained a FOIA lawsuit against an entity on behalf of a client?
Wow, ever? That's a tough question to answer sitting here. Ever. I remember one situation not too many years ago, trying to not go back over the better part of 40 years, but I had a private client involved with a lake weed treatment issue in St. Joseph County, which is in southwest Michigan. And sitting here today, I want to say from memory that I think the legal actions that were taken on behalf of that client included administrative and/or judicial appeal of a denial of his FOIA request.
Fair enough. What about defending FOIA actions? And in that sense, I would say both with regards to dealing with appeals to denials of Freedom of Information Act requests, as well as lawsuits such as the instant one in Count 1 and Count 2. Have you defended those before on behalf of townships?
Sitting here today, I can't give you specifics, but it's pretty plausible to say that I probably have at some point, just over almost 40 years. But I can't drag out a specific instance today.
Do you consider yourself to be well versed in the requirements and exemptions and such contained in the Freedom of Information Act?
Reasonably so. The legislature keeps making the law more complicated, at least it seems to me that's what is happening. But yeah, I would say reasonably so. And can I caveat that? Just to give you context. I would say it's not an everyday or every week or every month occurrence for any township client to contact me and request guidance on a FOIA request. Typically, I'm just not engaged in that on behalf of the township. They don't ask me. They may rely on other resources.
So are you saying that your relationship with the Township of Arcadia's FOIA coordinator, let's talk about the current FOIA coordinator, Patty Wilson, that's sort of an exception to the rule, the amount of advice that has been sought for you with regards to responding to those
Well,
requests?
I think the exception to the rule in the sense that if a clerk/FOIA coordinator is presented with a FOIA request with which that person is not sure how to properly respond under the law, it's that kind of situation in which that official would ordinarily pick up the phone or shoot me an email and request my involvement. And
Okay.
I think that was the nature of the request from Patty as to this request, seeking my assistance. What do I do with this?
Do you agree that a Freedom of Information Act response would have to identify with particularity the documents which the public body is withholding?
There is some statutory verbiage that I'm recollecting today that pertains to that subject matter.
Do you agree that there's statutory verbiage that would need to be included that informs a requester of their essentially appellate rights to either appeal it to the board or to seek relief from the local circuit court?
You're asking about my knowledge generally about what FOIA requires?
I'm asking if you know that that's a specific requirement.
I do.
Okay. And it would be fair to say that if someone asks you for advice on how to respond with the FOIA, you would tell them all. You would include all of that in your advice to them.
I don't know there's a one-size-fits-all answer to that.
Okay, well, and we'll move forward. So let's look at what's been marked as this deposition exhibit 4. And if I could just leave this one up here just so we can look at them in conjunction. Do you recognize that document?
Ooh. I don't know that I've seen this.
Okay, so
I may have, but I don't specifically know that today.
So if that was Patty Wilson, the FOIA coordinator's response or denial, essentially, of that Freedom of Information Act request exhibit 3 that we discussed, that would not have been something that she had run by you prior to responding in that manner?
No, I think I've indicated, I'm not recalling the specifics of the conversation or an email, if it was an email, but I think she did consult with me about Debbie's November 10 request.
And will you either you could read the request or I could read it. I don't know how you want to do it, but eventually I'm going to ask, I'll just read it. So the request, deposition exhibit 3, the November 10th, 2017 request asks for all communications via email, written, typed, document, or any other form of communication from Craig Rolfe to the Township Supervisor, Clerk, Trustees from November 2016 to present. So we can agree that that's what it requests?
Yes?
And now, looking at the clerk's response, the FOIA coordinator's exhibit 4, would you agree with me that that response does not meet the requirements of the Freedom of Information Act, and we can get into the details of what those requirements are? But on its face, would you agree that that is non-FOIA compliant denial.
DEP Exhibit 4 in and of itself
Being
as a standalone document.
that being the response to this request.
Well, there's no reference to Section 10 regarding appeal rights, for example.
And does that response, as far as you can tell, does it identify and describe the documents that are being withheld?
Just as much as the request does, which is all communications.
Is that your understanding that the response can be just as general as the request, or would you agree with me when I say that the response has the duty to identify the documents that it does not, or the person writing the denial has the duty to identify the documents that are being withheld?
Well, in the context of this specific request, Debbie's November 10 request, which was in and of itself a shotgun FOIA request, which specified no document requested specifically. I'm not particularly troubled by the nature of how the response is phrased as to a denial without enumerating, which I think is where you're going. If you're suggesting that the response should have, that a response should have enumerated every single document that would have been potentially responsive to the scope of the request, I don't know that I agree with that.
So
That's your point.
Well, that is my point. And so you think that this denial, by just citing the exemption and not identifying any document that's being withheld, do you think that that's sufficient under the Freedom of Information Act? And you would counsel someone like Ms. Wilson to submit such a denial?
Well, I'm not.
I'm just going to object in terms of attorney-client privilege, in terms of conversations with him and Ms. Wilson. But I think are you talking more generally, not saying Ms. Wilson, but a client?
Yeah, I guess a client.
Where the FOIA request itself, let me try to make this simple as I can. Where the FOIA request itself fails to identify with any specificity, specific documents being requested, I'm not horribly uncomfortable with the response from the FOIA coordinator responding in kind. Because to do otherwise would, I think, literally require the FOIA coordinator to engage in the process of identifying the requested documents. That's the responsibility of the requester to provide.
So that's your professional opinion, is that it's the responsibility of the requester?
Just object again, form and foundation in terms of professional opinion. He's not here to give you legal advice today, but I mean,
well, okay. Let me approach it this way. The statute, as I am recollecting it here today, provides an opportunity for a person to request public records. But that statute obligates the person making a request for public records to identify the records requested with sufficient specificity to enable the FOIA coordinator of that public body to identify those specific records.
Doesn't that request say all communications between the township attorney and, for example, the supervisor from 2016 to present? That's fairly straightforward, right?
I can read the words, and you read them into the record, and they haven't changed. The words say what they say,
Well, I'm just asking you to respond to my question.
which is,
The question is, it's fairly specific. It says all emails from this person to this person. 'Cause that's I mean, what is ambiguous about that?
well, I can understand what the verbiage says. It is in English. The point I'm making is I think there's a reasonable basis to question whether or not that meets the statutory requirement to specify sufficiently to enable the public body to find the requested records.
Is it true? Isn't it true that there would be emails between yourself and some of the individuals mentioned, for example, the supervisor, clerk, or a trustee?
I certainly presume so. I'm sorry,
That-
you were not done.
Isn't it true that there are emails that do not contain legal advice between you and some of these individuals?
I don't know how I could answer that without reviewing every single email I've ever sent to any of those persons.
Well, we can do that. Are you familiar with this stack of documents?
I see a stack of documents, and I'm not sure if I'm familiar with it or not.
Did you assist Mr. Weirda's office in obtaining information that would be responsive to a discovery request by my office to his office, or to his clients?
Mr. Weirda asked me to skim through a stack of papers in his conference room, and I did that. Whether that's the same stack of papers, I have no idea.
So you agree that you have provided documentation to him, or documents and emails to him in response to my discovery request?
No, that's not what I said at all.
You haven't provided him any documents?
I believe that's correct.
Okay. So is
I wasn't requested
So
to.
is your under oath testimony today that there would be no emails in your possession at the time that this FOIA request came in that would not, sorry, I'm doing triple negative there. Is your testimony that at the time that request came in, you did not have in your possession any emails that did not contain legal advice?
Are you asking the context of this FOIA request?
Yes,
Exhibit
sir.
3? Well, the FOIA request was for public records of Arcadia Township.
Do you agree
Records
that
in my file are not records in possession of Arcadia Township.
Do you agree that emails between you and the supervisor would be a record in the possession of the township?
Assuming that the township's record keeping retained them, which I have no control over or awareness of.
Okay, wouldn't you agree that that would be a record that would be potentially responsive to a request such as this? If it says all emails?
Certainly could be interpreted that way, yes. That would be a fair interpretation.
And there would be some of those emails that clearly contain legal advice, right?
Absolutely,
Yeah, probably a lot of them.
absolutely.
But there's also some emails that don't contain legal advice. Like an email about scheduling, for example.
Oh, perhaps, sure. That's a fair general assumption.
And would you also agree that when responding to to a FOIA request that's asking for emails that potentially contain information that would be covered by the attorney-client privilege, that the township would have a duty to at least look to try to separate the exempt from the non-exempt material?
If there were responsive emails that had non-exempt as well as exempt content, yes.
And your testimony today is that you cannot recall whether or not you engaged in this inquiry with with the township FOIA coordinator?
No,
in response to that?
I don't think I've said that at all. I think I've said that I don't recall the specific mode of the communication, but I'm pretty comfortable sitting here and telling you that I believe, sitting here today, that Patty Wilson did contact me in some manner and did request some assistance in responding to that FOIA request.
So there were documents that you guys identified together as potentially responsive?
No, I don't think my involvement went to that level at all.
But you did just testify that there's probably emails that would be all advice, and there's probably some emails that would not be advice. So you would agree that those types of things would be potentially responsive to that request, right?
Looking at it now, yes. With the benefit of hindsight, yes.
Okay, so with the benefit of hindsight, do you agree that the denial, Exhibit 4, is not compliant with the Act beyond the issue of not having the language from Section 10 from the Act in there?
If you're assuming that there's any content of any email that's a communication between myself and the township supervisor, clerk, or trustees within that time parameter that has some verbiage that's not protected by the attorney-client privilege, then yes. And I don't know the particulars, but yes, that would be an overly broad, arguably, invoking of the exemption.
Okay. Now, getting to the exemption, let's talk about the attorney-client privilege and the discussions that may or may not have been had, or how that extends within the township. You testified earlier that your duty is to the township as the municipality, as their attorney, right?
Correct.
And I want to take you back to, I think, perhaps the issue that brings us all here, which is the investigation and your role in regards to the marina fraud, so-called marina fraud. Do you know what I'm talking about?
I do.
And when you first were informed of this marina fraud, how did you learn about the search warrant for the township records with regards to this marina fraud complaint?
I think then clerk, Patrice Wisner, contacted me. Boy, not sure if that was initially by telephone or by email, but vaguely recollecting that I was contacted. And now this might have not been when the warrant was provided, but what I'm recollecting is some kind of communication with the clerk saying, I have a state trooper in the township hall, and he's telling me he's here about allegations of criminal fraud, I believe was the term that she told me he used to her, and he's requesting to see a bunch of records. Now, whether that was, did the trooper at that time, was that when he had the search warrant, or previously? Boy, that's
okay.
Not clear to me.
So that would be what you recall as the first sort of contact about that. How did you learn that that it was specifically Clerk Wisner? Is it Wisner?
Wisner.
Clerk Wisner and Dick and Joan Williamson that were the subjects of that complaint.
Let me just, after that last answer too, I want to just make this clear again. I'm going to object to any kind of disclosure of him of attorney-client privilege, which would include information given to him by township officials, employees, etc. I don't think you asked about it, but I think maybe some of it was volunteered on the last question. So I just generally want to put that out as a reminder not to disclose any attorney-client privileges.
Well, please allow me to express another concern, and council can decide what you want to do with this. But I'm being deposed in the context of this present case, which has 2 counts that pertain to FOIA request decisions made by the township, and a 3rd count that concerns expenses reimbursement. There's no count in this case that purports to litigate something to do with criminal fraud or the so-called marina investigation. So I'm not going to go very far down that road with you
Are
today.
you refusing to answer the question?
Not yet, but that's
All right.
probably coming.
Well, I guess I'll tell you why it's relevant, and I guess if we need to get a further court order.
Fire away.
Okay, do you agree that the exemption claimed with regards to this first FOIA request, November 10th, 2017, is the attorney-client privilege?
That's the ground stated on what you showed me as Dep Exhibit 4.
All right. And based on your familiarity with this case, I'm going to hand you Exhibit 6 and what's been marked as from the Exhibit 6 from the previous deposition and Exhibit 14 from this deposition.
Maybe just identify for the record what the new exhibit that you just marked is.
It is the denial that was attached to our complaint to Ms. Eckhout's December 14th, 2017 Freedom of Information Act request.
Thanks.
I've skimmed Dep Exhibit 14 first.
And would you agree with me that that document does invoke, again, the attorney-client privilege?
If I were to correlate the MCL citation, I believe that's one of the provisions cited, yes.
I'm going to point
One of 2.
I'm going to draw your attention to Exhibit 6 and item number 1. It's sort of a lengthy one, but I would just ask that you would just look at that.
And just parenthetically, I think this is Debbie's other FOIA requested issue in this case.
Yes, that's a
recollect
copy of it.
correctly.
That's not the one that was...
Right. But it's a exact copy
yeah,
of
it's
her
word for word.
December 14 dated request. Okay, and what are you asking me to
Mike,
look at, please?
Number 1 is a request based on one of your billings. I believe it's your January 1st, 2017 billing. And I would just ask that you look at the request and what it's requesting, and then we can discuss further why my questions about the marina fraud are relevant, if that's a concern of yours.
How far do you want me to go?
Just, can we agree that first request, number 1, does deal with a billing that's associated with your investigation or your participation in sort of dealing with that law enforcement investigation?
Item number 1 of this FOIA request relates to emails, correspondence, and documents referenced in what I take to be the billing statement from me dated January 1, 2017.
Yes.
What's on that billing? I have no idea.
I've itemized what was on the billing specifically with the specific time dates that the work was done.
That's what these entries are?
Well, yeah, until it gets to number 2. So that would all have been taken from your billing.
All right. So I haven't read all those, but
Okay.
go ahead.
All right. So obviously you can object later on, but so we would agree that number 1 is being denied. Request number 1 is being denied in the response to the December 14th, 2001 or 2017 request. Is that your understanding of that denial?
I'm sorry, say that again, please.
The request for this information, which is number 1 of the December 14th, 2017 FOIA request,
Right.
that information, those public records, were not provided per this denial, which is Exhibit 14, and there's 2 exemptions being cited for why they were not provided. Is that?
That's the conclusion I would draw from the wording of this 3-line
Okay.
paragraph that you just pointed to
Okay, so
in Dep Exhibit 14.
So, again, when you learned about this investigation, at some point you learned or you came to believe that the subjects of that investigation were former Clerk Wisner and Joan and Dick Williamson, who were the harbor master and his wife at that time. Is that correct?
I don't know if that's correct, and maybe I should explain that.
Well,
I know that. Okay, let me have a go at it this way. When I had the very first contact from a township official, which I think was Patrice Wisner, then clerk, about a state trooper showing up at the township hall, telling her out of the blue that he was there to investigate a criminal fraud, her words to me about his words to her, the trooper's words to her. She did not communicate to me, and it was my impression that the trooper did not communicate to her, who or what was the subject of his, quote, criminal fraud, close quote, investigation. Somebody may have known. I did not know. And I don't think that Patrice Wisner knew at that time why the trooper was there. Who was he investigating? Was he investigating the township? Was he investigating specific officials or employees of the township? He did not. If he told her, that was not communicated to me, as I'm sitting here recollecting that conversation today. Now, and that approach by the trooper set the tone, so to speak, for how I viewed the appropriate initial legal guidance to the township from me. Let me try to answer your question though. I subsequently saw those 3 names you mentioned in the trooper's written reports, which I only was able to obtain by a FOIA request to the Michigan State Police, because they wouldn't voluntarily disclose. They wouldn't voluntarily tell us anything. They wouldn't tell me anything. So I found out through the first FOIA request that those names were, that's how I found out officially, those names were referenced in his so-called investigation. Before I got the FOIA request, I think, and I'm just recollecting as best I can here, that someone, probably the then clerk, Patrice Wisner, told me that local scuttlebutt was that the trooper's investigation had something to do with the hours put forward by Dick and or Joan Williamson. But that was scuttlebutt at that time.
Would you agree that at that point in time, with the limited information you had, you could not ascertain essentially whose interests were aligned with the township as a whole and who potentially could be, whether they were defrauding or committing a crime against the township?
My interest at that time was providing legal guidance that was intended to protect the legal interests of the township, based in large part what I did not know, which was a lot.
At some point you prepared affidavits for Dick and Joan Williamson?
I'm going to object again. I think there's a pending attorney grievance commission grievance that's been filed on this issue, and I'm not sure if you're trying to conduct discovery on that. I mean, we're here about documents and reimbursements, and I'm trying to give you some latitude, but we're not going to go into issues that might pertain to a grievance that is not part of this lawsuit.
Are you instructing him not to answer the question?
I'm stating the objection that I just stated.
Okay, I would again go back to the fact that your clients claimed the attorney-client privilege exemption. I do not believe that attorney-client privilege extends to the harbor master or his wife at the time that this occurred, and therefore that would have been a violation of the Freedom of Information Act to claim an exemption. Furthermore, the exemptions that are claimed with regards to communications between this attorney and the Michigan State Police were not protected by the were not protected by disclosure by the attorney-client privilege. And I'm going to, we're going to go through this, and it's going to take as much time as it will, but that's what this case is about. So that's why this is relevant. I don't care about the fraud. I don't care about what actually happened. I just care about who's claiming these exemptions, and are they're, as clearly has been done, they were being claimed haphazardly by the FOIA coordinator. So it's not Mr. Rolfe's fault. I just got to understand from him.
So just so I understand, your only interest is the extent to which the attorney-client privilege did or did not apply to documents that were requested. I mean,
that's why we're here.
Okay.
So.
Okay. I'm still gonna, to the extent I feel like you wander too far into something that might be relevant to that, I might object. But understanding that that's where you're going, I can see how that's appropriate. I just hope the questions go that route.
At some point, you did prepare those affidavits.
I'm comfortable answering the question, although not really in the context of this deposition, because this is off in the weeds. But if you were to look at my billing statements to my client, the township, which I consider fully public records, by the way, no exception, always, I'm pretty sure you would find a billing item in at least one of those monthly billing statements that would reflect time I expended with respect to an affidavit of Bill and or Joan Williamson.
Okay.
Yeah.
Pretty
sure.
At whose direction did you do that? Was there a resolution passed by the township board that directed you to assist them?
If there was, I'm not aware of it.
Okay. Do you agree that their interest could have potentially been adverse to the interest of the township, the municipality?
Could have been, not based on the information imparted to me.
Well, if they in fact were committing fraud against the township, wouldn't that be something that, would you represent them in a criminal case against them?
No.
Okay.
No.
So at the time, any information that you gleaned from Dick and Joan Williamson, that information would have been something that you would be obligated to share with your client, the municipality, had this gone any further and had this evolved into a full-blown criminal prosecution of those two individuals for their crimes against the township.
Well, there's a lot of ifs there, and you're missing some important actual facts. And I'm not going to tell you today, or any day, what Dick Williamson and or Joan Williamson told me specifically, because they were communicating with me as employees of the township, my client. But I will tell you that based on what Mr. and Mrs. Williamson did tell me, I was very comfortable in concluding that their legal interests were well aligned with the township's legal interests.
So you made that determination?
I did, based on what they told me. Based on the facts that they related to me, not just orally, but then in what you later see as an affidavit.
And you believe that there's attorney-client privilege that extends between you and Dick Williamson in regards to that investigation, and you and Joan Williamson in regard to that investigation?
In their capacity as employees of the township.
And that would be information that would then, since it's in their capacity as employees of the township, that would be information that would be shared with the township board, right?
The board was provided copies of their affidavits, so yes, it was shared with the board.
Right, but isn't it also true that at some point you determined that you were going to advise the Clerk Wisner, and other individuals not to share the information regarding this investigation with the treasurer?
I don't know. I don't know. I can tell you that when it became apparent that the treasurer and her deputy were the complainants that initiated, to the Michigan State Police, that initiated that investigation after at least one of them publicly denied being a complainant, it seemed to me, and by the way, in the context of neither of those individuals, according to what township board members told me, neither of those persons having brought their concerns to the board to discuss and deal with, it appeared to me, and was my conclusion for purposes of going forward, that the interest of the treasurer and her deputy were not well aligned with the interest of the township generally on that specific matter.
So because the treasurer was the complainant and had reported a fraud, you believed at that point in time that her interests were adverse, so therefore you began shielding her from certain communications.
Objection, form, and foundation. You can answer.
That's probably correct.
So at that point, you did not have so at that point, was there a breakdown of the attorney-client privilege with regards to the township board being the fact that the treasurer was a member of that board?
I don't know if I'd say it's a breakdown. It made communication more difficult.
Is it fair to say that there was information that emails, communications that were being withheld from the treasurer at that time, but when the treasurer emailed you directly, you shared those communications with other members of the board?
Shared what communications?
My question is, are there communications that you were protecting between you and Clerk Wisner or other members of the board that you were not providing to the treasurer, while at the same time, if the treasurer contacted you, you shared that information with the Clerk Wisner?
Okay, just an objection on form and foundation. All right, you're asking every
I don't know
time.
how to. I don't know how to answer that question. It seems like there's too many moving parts of that question. In all honesty, I don't know how I can truthfully answer that question with any answer. Was Debbie privy to some of the particulars through me? Probably not.
And if she had contacted you when she did request information from you, correct? You do recall those instances?
I think I recall one or two.
And
yeah.
you do recall responding to the clerk in email that you were going to ignore those requests from the treasurer?
I do remember that.
Okay.
Yeah, I do specifically remember that.
So she was a member of the board at that time, and we agree on that, right?
Yes, of course.
And she was the treasurer of the Township of Arcadia.
She was.
And you made the decision that you were going to start withholding information from her.
Just object to the use of the word withhold information to the extent it's trying to con out some kind of bad behavior. If you can answer the question.
Well, for better or worse, right or wrong, I was not anxious to include anxious to include in the information process some sensitive issues that related to that whole matter that she was the initiating complainant for. Yeah, true.
Well, so she was a complainant in that instance. Let's move to the instance where she was the subject of an investigation. in conjunction with individuals of the township board, whether you, I don't need to know what you counseled them on, but Greg Wisner did make a police report to the Manistee Sheriff's Department, correct?
I was told that.
Yeah, and you at least had some communications, not asking for the specific of the communication, but there were some communications with regards to that with members of the board, the clerk, supervisor. Speaking of Supervisor McCrainer at this time.
Well, there were certainly some communications from me to members of the board, including specifically Supervisor McCrainer, about issues, legal issues, that were identified by me relative to the treasurer. But I don't know if those were the same. I don't think I've ever seen whatever the complaint was that Trustee Wisner filed with the Manistee County Sheriff's Department. So I'd have to assume.
You never
that
communicated with Sergeant Soper, Detective Sergeant Scott Soper, in regards to that investigation?
I introduced myself to him at a township board meeting. I think that was early this year. I know I'd not prior to that actually met the man, although he might have been in the meeting room, and I didn't know who he was prior to that. I don't know if I don't recall having direct communication with him. Well, if I did, I'm not remembering it, sitting here today.
And would you agree that you had decided that, I think you said you weren't eager to share information, I don't know exactly what the phrase was with regards when Ms. Eckhout was a complainant in the marina fraud, but is it fair to say that there were certain communications between you and the supervisor, or perhaps the clerk, that again were not being shared with the treasurer at that time now because she was the subject of the investigation?
Absolutely, true.
What aid did you provide to the treasurer, knowing that she was the subject of an investigation and she being on the board, that to assist her in how to deal with that investigation?
I don't know that I provided her any.
Okay, so...
And nor do I recall being asked to provide her any.
Well, with regard to the harbor master issue, who asked you? It wasn't the township board resolution that directed you to help to provide aid. You just decided to do that on your own, or?
You know, in probably my entire legal career, I doubt that I've ever been directed to take certain actions by a resolution of the township board, ever. That's not the way township government works, and certainly when you're dealing with smaller, and I don't use this term in a judgmental way, but less sophisticated municipal entities like little townships, which is much of my client base, my choice. It's not the way they work. It's just not the way it works. Maybe it works that way somewhere, but it's not the way it works anywhere in my experience. Municipal officials, members of the board who are elected, sometimes appointed, typically elected, to serve on the governing body of that municipal entity, have to do certain things to do the public's business. And this township, to my knowledge, has not had, and never brought to my attention at least, a township attorney use policy. And I don't think I have I'm not sure if I have a township client that has a township attorney use policy. Maybe one. But the way it works generally is a member of the board, the governing body, or another official of the township who's dealing with a particular matter within their area of service, could be a planning commission member, for example, they contact me and say, hey, can you provide legal guidance on such and such? Sure. And whenever that happens, my working operable assumption is that I don't need to conduct a national security investigation to determine if that person is authorized to make a request of the township attorney for some legal guidance on a matter of public concern. I provide the requested legal guidance to the best of my capability. I don't know how else to
So you
answer that.
you gave legal advice to Clerk Wisner in conjunction with the marina fraud.
I gave legal guidance to the township in conjunction with that marina investigation, for which no fraud was found, by the way. And
Who did you give the guidance to?
I would have had communications on that with then Clerk Wisner, probably some to then Supervisor Doug Carter, probably now Supervisor Janice McCrainer, possibly now Clerk Patty Wilson. I suspect trustees would have been included on some things if they were the person, especially if they were the person who were asking me a question. And yeah.
So, but you did specifically provide legal advice with regards to how to deal with the warrant and stuff like that, and the arrest potential to Dick Williamson and Joan Williamson, right?
The warrant?
Did you provide any advice to those individuals?
To the Williamsons?
Yes.
The only search warrant that I'm aware of, what I'm recollecting sitting here today, was brought forward by the trooper for certain township records, if I'm remembering that correctly.
So your
And
testimony.
those records were, I believe that was directed to the keeper of the records, the statutory custodian, the clerk. I don't know that that Dick or Joan Williamson were directly involved in a search warrant request. I don't know that.
And maybe I
if they were.
misspoke. So, but did you provide advice to them directly in conjunction with the investigation?
Did I provide them advice? My contacts with them were designed and intended to find out what the facts were. Along the way, did I suggest to them how they ought to conduct themselves in the face of what we understood to be some broad brush, quote, criminal fraud, close quote, investigation? I probably did, suggesting how they might conduct themselves as employees of the township.
Do you believe that any communications between you and the Williamsons would be protected by the attorney-client privilege?
Yeah, I think so. Given that my limited involvement with them, yeah, I think so, because of the focus of that legal guidance.
Would they be protected from disclosure to the rest of the township board?
I'm just going to again object on form and foundation. I think it's vague, but if you could answer that general question.
Wow. Off the cuff, unresearched. I'm going to say probably not, because in fact, although, like I said before, again, my communications with Dick and Joan Williamson, as I'm recollecting them here today, and those were sometimes emails, sometimes phone conversations, maybe my focus was on, what are the facts? I mean, literally, what are the facts? That's what I wanted to know. And to find those facts, I wasn't interested in providing them legal guidance. I wanted to know what the facts were. Along the way, and these people were, I don't want to say scared, but from what from how they made comments to me, these people were distraught that what they thought was their good reputation and their good work in the community was being destroyed by some malicious accusations. And that came through in our communications with each other.
Did you take a break shortly?
Yeah, we can take one right now. if
Yes,
you
we
want.
do. Let's take one now.
Okay.
Great.
We are going off the record at the end of disc 1 of the video deposition of Craig Rolfe, and the time is 2:01 p.m. We are back on the record at the beginning of disc 2 of the video deposition of Craig Rolfe, and the time is 2:11 p.m.
Mr. Rolfe, we were discussing sort of some of the communications, advice, and involvement with Joan and Dick Williamson in regards to the marina fraud. My next question would be, and again, I'm really interested in the, I guess, for lack of a better term, the lines of privity that run in the attorney-client privilege, as was your perception and the perception potentially of the township at the time of these FOIA requests by the treasurer. Do you believe that there's an attorney-client privilege between you as township attorney and the treasurer?
I think the privilege extends to officials and employees of the township, yes, of the municipal entity. So I guess the answer to that would be yes.
And so you will also believe that there is an attorney-client privilege between you as a township attorney and the clerk?
Correct.
Insofar as you just answered that it's
Yes.
the township as a whole.
Yes.
And that would be the same for the supervisor.
True.
And that would be the same for any trustee or board member.
That's my understanding and belief, yes.
And you believe that that extends to the harbor master?
As an employee of the township on township matters, yes.
And that would also extend to the harbor master's wife then at that time?
In her capacity as an employee of the township, in the context of township matters, yes.
Is anything revealed to you by any of those individuals protected from disclosure, the few individuals that we've just mentioned, protected from disclosure to any of those other, I guess, let me rephrase, I'm sorry. Is anything revealed to you by the people in their positions that we've just discussed privileged from anyone else that we've just mentioned?
I would think in a general situation, no.
So your communications with, for example, Dick Williamson would not be privileged from the clerk?
I think I'm comfortable agreeing with that, yes.
And your communications with the treasurer would not be privileged from the
And
supervisor?
we're talking in a general course here, yes, true.
And so would you agree that your communications with Dick and Joan Williamson and Patrice Wisner in regards to the marina fraud would not be protected by the attorney-client privilege with regards to the treasurer?
Well, that gets a little more complicated because the treasurer was the individual, according to the police reports I saw, who initiated, who made the allegation that initiated this so-called marina investigation by the Michigan State Police.
But couldn't you, in one light, view that allegation as being in the interest of the township? Someone is committing a fraud on the township, I report it to the police?
If my inquiries of individuals directly involved with those allegations, once I knew who they were, if my inquiries led me to conclude that there was in fact something that was going on that was unlawful, that of course would have been a game changer. But that was not the conclusion I could draw based on information related to me.
But-
those individuals.
And had that been the case, then you no longer would owe your duty as an attorney to the individuals that you believed had committed the fraud, but instead you would then turn to the township?
Well, I never had a duty owed to those individual employees. Again, my duty, one of your very first questions, my professional responsibility is to the client, which is the municipal entity.
So,
Those people were employees of the entity, the Williamsons. I did not represent the Williamsons in any capacity, and in fact, I don't think this breaches attorney-client privilege. I made very clear to them in, I suspect, conversation number 1, that I was not their attorney. I was interested in, not their attorney individually. And in fact, I was assured at some point, I recall Mr. Williamson telling me at one point that that's they understood, because he in fact had some kind of a communication with what he viewed, what I understood he viewed as his personal attorney. It was not me.
and you would agree that any information obtained by you would then be certainly information that should be obtained or that should be shared with the township board in order that they can make decisions in the township's interest.
If there were decisions to be made, yes, the information would have been imparted to members of the board who were not, at least two were not, from my perspective, conflicted out of making determination.
So you made a determination that the treasurer was conflicted out of those discussions, is your position?
Based on what clearly was the adversarial nature of how the matter was initiated by her and her deputy. Yes, I think that's, I don't know if that's the correct terminology, but the gist of that, yes, I agree with that.
But we could also agree that when, let's say, the shoe was on the other foot and there was a criminal investigation of the treasurer, you did not provide those same services to the treasurer that you did to Dick and Joan Williamson and Patrice Wisner.
I'm just going to object that we've been through all this. It's
Yeah,
been asked and
I
answered
don't-
multiple times.
yeah,
I don't
I
know why
think
we got to
so.
repeat it.
I don't recall the treasurer asking me to provide her legal guidance on the issues of which you speak.
But based on your statements, if she had asked you for legal guidance, you would be obligated to share that with the rest of the township board because you represent the township.
I would say as a general proposition, a general statement, yes. In general, yes.
And you would agree that there's no attorney-client privilege between you and the Michigan State Police.
Yeah, I would agree with that.
So any
Sure.
information that they disclose to you would not be protected by the attorney-client privilege.
I think that's, yeah, true. As to between me and my client, yeah, true.
So when the FOIA coordinator denied the plaintiff's or the plaintiff's request with regards to her December 14th Freedom of Information Act request and cited the attorney-client privilege with regards to your communications with law enforcement, that would not be an accurate invocation of that exemption, right?
I don't recall, without going through all these numbered paragraphs, I don't know that this request, the December 14, 2017 request, requested MSP documents that the township had in its possession once MSP responded to the FOIA request. I provided the documents that I received from the state of Michigan in response to the FOIA request to the state of Michigan Michigan State Police. Those documents were forthwith copied and sent to my client, on whose behalf in whose name I made the FOIA request.
So for example, like email to Trooper Hall at Cadillac Post requesting copy of any warrant application and supporting affidavits, would you agree that that would not be covered by the attorney-client privilege?
Sitting here today, with my understanding today of the scope of attorney-client privilege, I think I would agree with that.
And you would agree that emails to Dick Williamson in response to a request for an update on what was going on that would discuss sort of where your FOIA request was or what information you were receiving from law enforcement, that would also not be covered by the attorney-client privilege?
Sitting here today, a denial that broadly covered this enormous list of records would probably be invoked too broadly. Today I would have that that understanding.
And part of your concern with, I believe it's Exhibit 3, the request was that it was extremely broad. You agree that the request in Deposition Exhibit 6, which is the December 14th, 2017 request, is extremely specific, correct?
It's certainly more specific. Yeah.
Did you and we discussed it sort of in depth on the first FOIA request, but with regards to this December 14th request, did you and the clerk, did you together identify records that would be responsive to that request?
This request?
Yes, sir.
Exhibit 6. I don't think so. I'm not remembering getting together, as you say, with the clerk for that purpose or to do that. Let me think for a minute. My best recollection today is that we may have had a conversation in one form or another. It might have been telephone, might have been email. But I don't remember sitting down with the clerk and going through these enumerated paragraphs of the December 14 request with specificity. I don't remember doing that. I don't think we did, but I don't remember doing it.
Okay, and so you use the verbiage knowing now what you know today, but would you agree that whatever efforts were made to separate the exempt from non-exempt materials were insufficient under the Freedom of Information Act with regards to that December 21st denial?
I mean, yeah, I think that's a fair statement, and because at the time of these requests, my understanding of the scope of the attorney-client privilege was such that it was a very broad and comprehensive privilege that applied to communications to, from the client and the attorney. And I think that understanding of that broad scope of FOIA, if you ask 10 municipal attorneys, I suspect you'd have the same understanding with quite a few of those attorneys. Sitting here today, my understanding is that the scope of the privilege is not as broad and absolute, is perhaps one way to put it, as I thought it was at that time. And it's important to me sitting here today, and Mr. Weirda might kick me if he could, but that Patty Wilson not be thrown under the bus. That is important to me. She conferred with me. She brought these requests to my attention. She directly or implicitly asked me what should I do with these. The first request was just extremely shotgun in its nature. The second request was everything, including the kitchen sink, and was very daunting just looking at it. She elicited my legal guidance. I gave her legal guidance. It's my impression sitting here today that her written responses in both instances were not necessarily embracing that legal guidance in its totality, but she did confer with me, and I did provide her some guidance based on my understanding of the law at that time.
Would you agree that her, at least her actions with regards to these two FOIA requests and her denials were not really rooted in any sort of principled approach to dealing with Freedom of Information Act requests?
Just object on forum grounds.
No, I don't know that I would agree with that. When my recollection, again, without disclosing specifics, legal communications to me or from me, because I think those are clearly protected. Whatever we may quibble about with the scope of the privilege, I don't think anybody would think that that's not covered by the privilege. But no, I don't. If they're suggesting that she or I dealt with these flippantly, I don't think that's a proper characterization. Using that for a corollary to dealing with them in a principled way, I think was the word you used.
But what were the principles that were guiding your guys, the approach that you took to them? Because what I'm hearing is that we invoked too broad of a privilege, and we didn't engage in the inquiry to separate the exempt and non-exempt materials, at least to the level required by the Act. So I'm just, where is the approach coming from? That was your personal approach that you then, I don't care what you actually advised her, but was that, I mean, where did you get the basis for responding to them in this manner?
I would say that it's fair to understand that the clerk's response relied in significant part on legal guidance that she received from me, from the township attorney. And on her part and mine, in an attempt to follow what we understood to be the law, but like I've indicated, my understanding here today of the scope of the privilege is different than it was then.
But what about the understanding with the duty to essentially identify the documents that were being withheld and describe them with particularity?
As to the first one?
As to both.
Specifically? Oh, as to both. I don't know that that's, sitting here today, I don't know that I agree that that's what the law would require.
You don't believe that the law requires you to identify the documents that you're withholding?
I'm not sure sitting here today it matters whether I think that or not.
Well, I guess that's not really responsive to my question, but so I guess I'll ask it again. Do you believe that is a consideration do you believe that you have to identify and describe with particularity the documents that are being withheld?
That's not my understanding of the statutory requirement.
So if the clerk failed to do that as a FOIA coordinator, that would be essentially because of her reliance on you then?
Object on foundation grounds.
It's hard for me to answer that without getting into what I may have advised or not advised, and I think that's a line that we shouldn't cross, don't have to cross. No, I don't think that'd be a correct understanding on your part necessarily.
Well, I'm just trying to figure out if you're giving her legal advice that's in fact the opposite of what the Freedom of Information Act says, then I'm just trying to get to what the basis for that would be. Because if you're saying that as you sit here today, you do not believe that the public body has a duty to identify and describe with particularity each document that's being withheld, or engage in the inquiry of identifying those documents and separating the exempt from non-exempt material, then I'm curious as to what principles the determination to write these blanket denials, how it was made.
Those are two different issues under the statute, I think. And the first one, itemizing what's not being provided, I'm not able to discuss that today. The second one, I think I've already essentially answered that.
Do you recall an email that you sent some time ago, essentially encouraging the supervisor, Janice McCraner, to give a pep talk to the clerk Wisner about why she shouldn't quit, why she should remain in her position?
Yeah, I have a vague recollection of sending her such an email, yes.
Do you agree that that is not advice provided by an attorney to a client?
I don't know that I would agree with that necessarily.
You think that would be that was properly withheld from response to the first FOIA request?
I don't know.
Okay. Do you also agree, or do you agree that essentially all of the documents that were requested in Ms. Eckhout's first FOIA request, the Exhibit 3, as well as all of the documents that are requested in Exhibit 6, should have been provided to the treasurer in her official capacity?
Just going to object on form grounds. I don't understand the question, but if you do, you can answer it.
I can clarify if you need me to.
Well, I think I understand. I think you're just asking me in so many words whether I think the treasurer should have had access in her capacity as the treasurer, or member of the board, to all the documents that she requested in her FOIA request.
That's exactly
I think
what I'm
that's
asking you.
what you're asking me. And actually, I think as a matter of law, the answer to that is those are two different things.
That's not responsive to my question.
So that'd be a no then, because those are two different things, in my understanding of the law.
Well, we're sitting here today. Obviously, you recognize. I mean, you recognize that this is a extensive litigation. It's costly to all the parties involved, and so my question to you again is that isn't it true that all this could have been avoided if, as you say, your duty to the entire township as a whole, the municipality, that all these communications which were in the interest of the township, the municipality, which Ms. Eckhout is a board member, in fact, the treasurer of that municipality, that all of these documents, which, regardless of the exemptions that are being claimed in regards to these denials, that they were all generated in the interest of the township and they should have been shared with her as a board member.
Yeah, and I don't think I do agree with that. I think I do not agree with that.
What is the legal basis for that opinion?
I don't know of any statute that gives blanket access to all records of the township to the treasurer. I don't think there is such a statute. There's a statute that gives the treasurer as an individual the same rights anyone else has. has to make a request for public records under the Freedom of Information Act, which she did here.
So you're saying that as a township attorney, you get to make the decision for what information is withheld from which board member, and you're making the ultimate decisions as what's in the interest of the township without disclosing this information?
I don't think that's what I'm saying. I think I'm saying that I don't agree with your statement that because the treasurer is a treasurer, she has an automatic legal entitlement to every record generated by anyone in any capacity with the township.
What about just with regards to the township attorney?
Well, that would depend too now, wouldn't it? Because is the treasurer entitled to communications I might have made involving a matter in which she's suing the township? I don't think so.
Well, that's just one instance, because you started withholding information from her as early as, I don't know, the beginning of 2017 when you were dealing with the marina fraud investigation, and you had a different reason at that time.
Objection again to form and foundation. I mean, I'm not sure there's a question. I think maybe it was just a statement, but.
I was getting to the question, but
Okay,
so
go ahead.
So again, now you're invoking the lawsuit, but it seems that essentially what you've been doing is just coming up with different excuses along the way to withhold information from the treasurer that she as a board member would be entitled to in order to make informed decisions on behalf of the township.
Objection, argumentative. You can answer.
Well, I don't agree that records were withheld from the treasurer based on some edict by me or anyone else to deprive her of records that she would have been entitled to under the law simply because she's the treasurer. I don't agree with that. I don't think that is the case.
So, but you do agree that because you had determined that the treasurer was in some way hostile to the interest of at least some individuals on the board that perhaps you were more closely aligned with, that information was withheld, which was shared with some board members and not with her.
Again, objection, form and foundation, and the compound nature of the question, but if you can get through that.
I'll try. As I think I've already alluded to, maybe not in these words, so let's give it a go this way. When the treasurer initiated the so-called marina investigation conducted by the state police, in the context of not having raised whatever her concerns were to her colleagues on the township board, to the board as the employer of individuals of which she apparently had concerns, we found out later, and just went off and attempted to subject the township to what they were told was a criminal fraud investigation. She, in my opinion, she established an adversarial relationship between herself and the other members of the board.
But how can that be true if she in fact thought there was a crime? If a person thinks there's a crime being committed against the township and reports the crime, how is that adversarial to the township? Now you're talking about the members of the board. I thought we were talking about the township because everybody owes a duty to the township, right?
Yeah, I'm talking about the township, but the board is the governing body of the township and therefore the employer, if you will. And it was just baffling, at least to me, unless of course there was an ulterior motive, why Debbie would not have brought her concerns forward to the governing body of the township and said, hey, I have some concerns. Here they are. Here's why. Can we talk about this? My understanding is, from what other board members have told me, and this has never been contradicted, that never happened.
Is there a legal requirement for that?
I actually think there probably is, as a fiduciary, as part of her fiduciary duty to the township, to come forward to the body of the township that actually has the authority to do something about this, whatever this may be in her concerns, and bring those concerns to them. And yes, I'm familiar with the whistleblower statute. I understand all that, blah, blah, blah. But why she would not have brought her concerns forward to the township board, her colleagues on the board, is just, I'm mystified.
Is it fair to say that that action then sort of set the tone for all the future interactions that you've then had with the treasurer?
Well, it's fair to say that that gave me some pause for concern about what the true motivations of the treasurer were in initiating this, in expressing her concerns in the manner and to whom she did. And those concerns were, I would say, amplified when I reached out to the principals and sought factual information and requested that factual information be reflected in a form that was essentially under oath, an affidavit. And I wasn't receiving factual information that validated these concerns. It was contrary to that.
And so since that time, there have been, now there's three different issues. We have the issue of the harbor, the marina fraud allegations investigation. We have the investigation of the treasurer herself for an alleged fraud, which also was determined not to be an actual fraud by both the forensic auditor as well as the Manistee County Sheriff's Department. And then we have now this lawsuit. So in all of these instances, you have justifications for withholding information from the treasurer as a member of the board and sharing it only with certain people that you deem reasonable within the township. Is that I mean, that's true, right?
No, I don't think so. And you got to back up a little bit, because your second point, I'm not aware that the township, that the work done by an auditor was based on a concern or based on any information that the treasurer was defrauding the township. And you said it was based on a fraud investigation. I'm not aware that that was the purpose for engaging that auditor at all. Maybe it was, but not to my knowledge.
Are you aware that the township is refusing to pay the auditor because they believe that he's acting in collusion with the treasurer?
I'm aware that there is I think, ongoing disagreement as to what fees that auditor is entitled to based on the agreement he submitted that engaged his services with the township. I'm aware of that.
But again, I guess, and sorry if I convoluted, I'll go back and say there's three specific instances for which you have deemed justification for having communications with some members of the board that you do not believe should be shared with the treasurer. And that began with the marina fraud investigation. It had to do with whatever the investigation of with regards to the treasurer's duties that encompassed Mr. Wisner's report to Manistee County Sheriff's Department and the finding and the engagement of the forensic auditor. And then lastly, as you've just stated, this lawsuit itself, that you do not believe that those communications should be shared with her.
Okay,
those are three separate, you've given all those reasons today, so I'm just asking you, those are reasons for sharing information with some members of the board that you've deemed that you want to share that information with and withholding it from the treasurer, correct?
Objection, form and foundation.
Yeah, I'm not sure what the question is. I'll try to answer it this way. There were circumstances created by the actions of the treasurer that established in multiple instances a relationship that was adversarial in nature. And if you take the marina investigation, for example, would I have found it prudent to share with the complainant who initiated that investigation certain information provided to me upon my inquiries, intending to find out what the facts were? No, I would not have been anxious to share that information with that complainant.
So at that point in time, there's a breakdown of your attorney-client privilege with the township as regards the treasurer.
No, I don't see it that way.
Well, you're ignoring emails from the treasurer, right? Requests for information, you ignored those. You specifically said, I'm ignoring this in your responses to certain emails.
I thought that was the prudent and entirely permissible course at that time, yes.
Based on what?
Based on the fact that, I don't remember the subject of the email, by the way, but based on the fact that I didn't think she had a legal right to that information, whatever it was, in that manner. And again, she had established with situation after situation a relationship that became not merely adversarial but really hostile to the township.
Do you agree that emails to that effect, if an email to the clerk or the supervisor discussing an email correspondence from the treasurer and you indicating that you were not going to respond to that, that's not legal advice. That would not be subject to the attorney-client privilege. Is that correct?
With what I understand the scope of the privilege apparently to be today, probably not.
So you agree that that was a violation of the Freedom of Information Act to withhold that information in response to her request?
The basis to withhold that specific email in and of itself was probably thin, with benefit of hindsight and today's understanding of the less than absolute scope of the attorney-client privilege.
And additionally, so for example, I'm handing you, this is a document that was provided through the discovery process. In this case, I'm marking it as Exhibit 15 for the deposition of Craig Rolfe. Would you agree that that email would be responsive to both the first and second FOIA request at issue in this case, and that that does not contain legal, at least that that email in and of itself is not protected by the attorney-client privilege?
Well, the request from Debbie was asking me to advise the township board that they must preserve township computer, that it had a duty to do so, she stated. I would take that to be asking me to provide legal advice to the township board, and I declined to weigh in on that unless I was directed by the supervisor or board to weigh in on that.
So in this case, you decided not to weigh in on it unless you were directed by the township board or the supervisor, but when the clerk unilaterally contacted you about the search warrant and the marina fraud, you just aided her, you sought out Dick Williamson and Joan Williamson, and you just decided that was the course of action. But when the treasurer requested you to do something, you were going to wait for township board approval, even though you just testified that you never wait for township board approval to take an action.
The response was that I'm not otherwise responding to her email unless the supervisor or board requests I do so, which, given the nature of her request, I thought was the appropriate approach in that instance.
All right, I'm going to hand you what's been marked as deposition exhibit number 16 in the deposition of Craig Rolfe. It's actually several emails. I believe one email is from you. There's a previous email from a former clerk Wisner, and then at the bottom there's an email from the treasurer. Does that look somewhat familiar to you?
Okay, let me...
And just for record, that email is dated, is it July 12th?
July 12th.
2017.
Right. Looks like all of them were in the chain, were on the same date. I'm trying to orient myself to where this starts. Looks like it starts with Debbie's email to Patrice. About communications regarding the state police investigation, use of the township attorney, copies of emails. And the then clerk's response is the next one up the chain, indicating she didn't plan on responding to this, but apparently asking me to advise the supervisor as I see fit. If she wants to be advised, then my response, very quick input. Yeah, well, I mean, I don't know what's the question? I'm just
Do you agree
trying
that those emails contain information which is not protected by the attorney-client privilege, as it exists under the Freedom of Information Act?
Well, the email that Debbie sent to the clerk would not be protected by attorney-client privilege, but Debbie sent the email, so she presumably is aware of it.
Well, let me ask you about that. So, because she sent the email, if she as a regular person filed a Freedom of Information Act request, you believe that email should be withheld from her?
Her email at 10:31 a.m. to the then clerk?
Yeah.
Not on any grounds of attorney-client privilege.
And as well, at least part of the email sent from the clerk would not be protected either, correct? I don't intend on responding to this. That's not requesting for advice, and that's not advice. Is that correct?
Based on my understanding of the scope of the attorney-client privilege today, yeah, that's probably, I'd probably agree with you on that.
And at least part of your own response, when you say, you may find it just prudent to just ignore her email and see where it goes from here, if anywhere. So from my perspective, she created an adversarial relationship with the township on this particular matter and has not done anything to alter that even now. Would you agree that that's not legal advice?
Boy, that's close to the line. Not sure which way that would fall, honestly, but most of that, the tenor of that certainly, in my opinion, would be protectable.
Well, aren't those, when you're talking about relaying facts regarding the investigation, those are facts, right? The current status of an investigation has been closed, or if it's ongoing, those are facts, right?
Well, this, if I'm reading the email correctly, second paragraph, it didn't indicate that, doesn't reference the MSP investigation being concluded. It says, I'm sorry, it says although. Thought it was after. Although the MSP investigation is concluded.
I'm going to stop you right there. That's a
Yes.
fact, right?
Apparently.
Yeah. And if facts are not protected by the attorney-client privilege in that regard when it comes to communications under the Freedom of Information Act.
I think there's a basis to make that point based on what I understand now about the scope of the attorney-client privilege. Yes?
Okay, and then let's wrap it up here. So your early on, you said something about you didn't want the FOIA coordinator to fall on the sword. So are you falling on the sword here today? Is your testimony that the inadequacies associated with those FOIA denials and the reason that we're here today that's because of your misapprehension of the law at that time, or is it the clerk's misapprehension, or is it the combination?
I
of the
said
two?
I
Let
didn't.
me just make an objection a minute.
All right.
I'm going to object again on form and foundation and just ask if we could maybe keep out all the argumentative stuff and just ask the question. I think it would make the question much clearer and maybe allow us to continue forward a little bit better.
I'm not sure that was argumentative. I guess that's not my definition of argumentative. I'm just asking.
Fall on the sword.
That was his word.
You're taking
No, it was.
all of that stuff is what turns each question into a 35-second endeavor.
Well, when you do your depositions, you can do them however you want. My question is, you said that you didn't want her to fall on the sword. Those are your words. I'm not
Well,
making
actually,
these
it's
words
not what
up.
I said, but
Did you not use the word?
I'll tell you what I said if you let me answer the question.
And I'll be quiet so you can answer it.
All right.
Okay.
Let me preface this. My integrity is very important to me, professionally and personally. And I don't knowingly and willingly provide any client legal advice that I know to be inaccurate. I would like to think that no attorney would. Probably some do, not this one. To whatever extent, an appearance was created that Patty Wilson, as the clerk/FOIA coordinator, simply randomly, flippantly responded to these two FOIA requests with no guidance. I was uncomfortable with that impression being left in anyone's mind here. Because, as I stated, and I characterized it not as falling on the sword, but as having discomfort about throwing her under the bus.
Oh,
That's the
bus.
phrase I used. Probably the same basic idea. So what I tried to communicate was that these are people just trying to do their jobs, and I'm trying to do my job. And the clerk inquired of me as to, I think, both of these FOIA requests. Pretty sure of that. One way or another, orally and or email. And I'm equally pretty sure that I provided legal guidance to the clerk to help her in a response to those FOIA requests in her official capacity. At the time I provided the legal guidance to the clerk, my understanding of the scope of the attorney-client privilege was more absolute, more broad, whatever terminology you want to use, than I have subsequently understood the law may support. So, am I falling on the sword? I don't look at it that way. If you're asking me, did the clerk rely, at least in part, on my legal guidance to her in responding to these FOIA requests the way she did, the truthful and honest answer, in my opinion, is yes, she did. And that goes to not thinking it's fair to throw her under the bus as being the only person who had any involvement in this. So, did I err in some respect? Was my understanding of the scope of the attorney-client privilege less than perfect? Perhaps so, based on what I know today. But that's different than what my knowledge base was at that time. So I don't know what that means to your question about falling on the sword. That's a truthful response.
And as
To
to
your
the
question.
as to the endeavors to identify those records and separate the exempt from non-exempt materials, would the same answer be appropriate?
Well, in a sense, but not exactly appropriate or the same answer, for the simple reason that if, based on what was then a good faith understanding of the more absolute scope of that privilege, we weren't focused on, or I wasn't focused on redacting, separating.
Or providing the itemized list of what's being
Well, and that's
withheld
a-
because you don't believe
And
that's...
that's a different question. I'm just saying I'm not sure that's the law or not sitting here today.
Okay.
It may be, it may not be.
Well, if it is, then that wouldn't have been something that you would advise her to do.
Well, I would not have advised the clerk I would not advise the clerk to do something I believe to not be lawful under the statute as I understood it to apply.
But that being said, misunderstanding of the law or lack of education or whatever it may be on the part of the FOIA coordinator is not a defense to the Freedom of Information Act, to a claim under the Freedom of Information
Well, I
Act.
suppose that's a legal question, but as a general statement, I think that's probably true.
All right. Thank you.
You're welcome.
All done?
Yep.
I don't have any questions.
Oops. No, I shut down too soon.
You didn't say the
Second.
time,
No.
did you?
Wait. We are going off the record at the conclusion of the video deposition of Craig Rolfe, and the time is 3:03 p.m.